Good afternoon. This is Marcia Waters, Director of Doors Division of Real Estate. Today is January 8th, 2024, and the time is 2 p.m. I will now call the meeting to order. Before I call roll, I would like to advise the task force and members of the public that while the Division of Real Estate has been tasked with leading this task force and ultimately the issuance of the task force's report, the views, opinions, and recommendations discussed and expressed by the task force are not the views, opinions, and recommendations of the Division of Real Estate or the Department of Regulatory Agencies. And with that, I will now call roll. Joe McConnell.
Here.
Dr. Davis. Natasha O'Flaherty.
Here.
Brian Matisse.
Yeah, I'm present.
Bert Nadler.
Here.
Barry Wilson.
Here.
Representative Parenti.
Here.
Senator Gonzalez. Marianne McGreedy.
McGeady here.
McGeady, sorry.
That's okay.
Christopher Elliott. Jennifer Tanaka.
Here.
And Steve Odorizio. Well, it looks like we have a quorum, and I will turn it over to Sarah.
Wonderful. Thank you so much, Marcia. Appreciate you tossing me the baton. Hello, everyone. Happy New Year. Good to see everyone back. I'm sharing my slide deck right now. Are you all able to see it? Thumbs up if you can see my slides. All right, wonderful. Great. Well, we are at our third meeting of the Metropolitan District Homeowners Rights Task Force. And as you know, we are going to start our meeting with just a few best practices and reminders to just help reinforce how we're going to conduct our work together and also the objectives of our task force meetings. So I'm not going to go ahead and read all of these meeting norms. You can see them there. But just a reminder that it's essential for constructive discussion, that we all have a responsibility to uphold these meeting norms so that we can have a really productive conversation at the end of our 2 hours. The other thing I just wanted to remind everyone is not necessarily a meeting norm, but there may be times, because this is a more technical conversation, there may be moments where I pause the conversation to just get some clarification for the purposes of our final report, as well as for our audience members who are following along, so that we just have some clarity and ensure that we really do understand some of the content that you bring up today. So I will interject myself once in a while when that is the case. So today's agenda is covering 2 of our legislatively mandated topics. Our first educational topic today is on foreclosure. And each task member here, of course, has varying levels of expertise. And so we're very grateful to have David Furman with Altitude Community Law here today with us. And so, as is the case with all of our expert speakers, they have been invited here because they are subject matter experts and they are providing factual information on these topics. And so they're not going to be offering any personal opinions. And at the end of each of these facilitated sessions, that's when we're going to have our each of these topics. That's when we will have our opportunity to have a discussion around what is working well, what's not working well, and what some suggestions for improvement are. So as we listen to our expert speakers, just remember that they're not going to engage in the conversation. They really are just here to provide that factual information, and we'll save that debate for when we have our facilitated discussion. Our second topic is going to be on the process by which metropolitan districts enforces covenants and collects assessments could transition into a common interest community. This was another legislative mandated topic, and we have a couple of speakers who will be joining us for that as well. In the same format will follow for our facilitated discussion. So without further ado, I am going to go ahead and welcome our first speaker on foreclosure. We have David Furman, who is a shareholder in charge of finance at Altitude Community Law. David is a longtime resident of Colorado, attending the University of Denver for both undergraduate and law school. Out of law school, David's legal work concentrated on real estate law and development issues, including formation and creation of homeowners associations. Prior to entering the homeowners association world, David worked in the private sector, handling land acquisitions, land entitlements, corporate governance, and special districts. David has also worked with the Wheat Ridge Housing Authority and the Douglas County Housing Partnership to set up homeowner associations for income qualified housing developments. He's an active volunteer with the Community Association Institute and David has served on several committees and is a recognized industry leader, frequently representing or presenting for CAI at both the local and national level. And so, David, I am going to be advancing the slide deck for you. So I'm going to go ahead and pull that up right now, and we will go ahead and get started.
Thank you so much. And as to start with, I want to preface this that this deck, this presentation is actually part of a 2-hour educational offering we give to managers, to district leaders, and to homeowners that live in communities. So this is something that I'm going to really just hit the highlights because I was told I had about 10 minutes. So if we could do the next slide, please. So metropolitan districts, I think everybody may be aware, are their quasi-municipal corporation and political subdivision of the state of Colorado. They are organized through Title 32 of the Colorado Revised Statutes. Next slide, please. Section 32.1.1001 specifically authorizes a metro district to increase or decrease fees, rates, tolls, penalties, or charges for services, programs, and facilities furnished by that district. So they have a income or they have a fee-based structure as well as a taxing structure. Next slide, please. Please.
I apologize. My screen share went blank there. I could not advance the slides. Let me try this again.
Not a problem.
There we go. You all should see it now, correct?
Yes.
Right. Let's see if it's just not advancing for me, David. Okay, there we go.
There
Sorry.
Okay. So the district may also adopt and amend various resolutions of the board concerning the assessments of these fees, rates, tolls. So it's, again, the fees, rates, and tolls are generally board driven, not necessarily homeowner approved or homeowner driven. Next slide, please. The resolutions adopted by the district are similar to those adopted by HOAs and may include guidelines for notices to owners regarding delinquent balances or procedures for turnover to legal counsel for collection and or foreclosure. Property located within the district's boundaries are subject to the established fees, rates, tolls, charges. By fact that you own a property in the district boundaries, you are subject to these fees, charges, tolls as established by the district. Next slide, please. Okay, as I mentioned, by virtue of ownership of the real property, you're bound. And the key here is that owners are responsible for the payment of the district fees and other charges plus costs of collection, including attorney's fees and costs incurred to collect and or through a foreclosure. Next slide, please. The exemption CRS 3841-201 states the district's lien is not subject to the homestead exemption under Title 38, and the lien is in the nature of taxes. Now, a homeowner association, an HOA lien is what's referred to as a super lien, what is subject to the first deed of trust. The district's lien is not, and it is subject to all other lien holders are subject to the district's lien. Next slide, please. All such fees, rates, tolls, penalties, or other charges constitute a first and perpetual lien against the property pursuant to 38.1-1011JI. Next slide, please. When a district assesses a fee for services that a fee is not paid, the outstanding fees automatically become a statutory lien on the property, much like a tax lien. This does not have to be perfected in any manner. It is subject to the declaration and it is of record already. It's also, as I mentioned, a tax lien that's superior to all other liens except prior tax liens. So if they haven't paid their real property taxes that went delinquent first, this would fall behind it. Next slide, please. How is a lien foreclosed? A lien is foreclosed unlike the foreclosure of a deed of trust. The lien is foreclosed through a judicial foreclosure, meaning an actual lawsuit has to be served, going through all the processes. It's not a public trustee foreclosure or public trustee sale. This is more akin to an HOA lien that is judicially foreclosed as well. Next slide, please. The judicial foreclosure seeks the court's permission to sell the property and satisfy the debt owed to the district. A lender typically forecloses through the public trustee due to a power of sale in the loan documents. neither a district nor an HOA has the power of sale, and it actually has to go through the foreclosure process, which is the judicially mandated process. And it takes about a year. Next slide, please. CRS 32-1-1001 sets forth the powers of the district's board, and the district has the authority to file a court action to foreclose, which provides to the district the ability to sue and be sued and to be a party to suits, actions, and proceedings. So that's the organic statute that allows the district to do what they do. Next slide, please.
And David, just so you know, we're about halfway through the presentation time.
Perfect. Thank you so much. A lis pendens, again, is merely something the association or the district will record to put the world on notice that the property is in dispute or title to the property is in dispute, and it has to be foreclosed to protect the lien or perfect the lien. Next slide, please. Okay, foreclosure process. When it comes to an attorney to foreclose, the attorney will order and review title report to determine all the lien holders, because all the lien holders have to be named in the lawsuit, including the holder of the deed of trust, any other tax liens. The law firm will draft a lawsuit and the lis pendens to record it. You have to file the lawsuit with the court and record the lis pendens. You prepare documents for the process server. You monitor for service within the allotted amount of time period, which is usually 21 to 35 days, depending on the services in or out of state, and file an affidavit of service for each defendant with the court. You may request extensions for service as necessary if owners or you can't get in to serve some people. And then if the owner or other entity does not have an address that can't be found, you can request service by publication. This has been subject to a few lawsuits in recent years. Next slide, please. Okay, you have to confer with your counsel for the lender. Usually this is so that you can stipulate to lien priority, and what will happen is the lender will pay off the lien so they do not lose their lien position. You confer with other lien holders, such as second mortgagees, judgment creditors, prepare payoffs for junior lien holders wanting to retain their lien position, because as I mentioned, a judicial foreclosure of a district's lien will wipe out or dispose of all the other liens. You prepare the payoffs. You reply to answer any answers filed by any of the defendants. Next slide, please. If the owner or other defendant does not file a response or stipulate in some manner, we calculate the balance due and draft an affidavit of indebtedness to obtain a judgment and order of sale. And then you have to draft the motion and proposed order for the default judgment. So all this is court overseen. Next slide, please. The sale of property is governed by CRS 3838-100.3. The sale is held approximately 120 days following the entry of the order. So if you were to go out and get a court order, a default judgment, or any other order, it still takes about 120 days to initiate the sale. Documents prepared for the sheriff's sale include the notice of publication, the mailing to the owner and lien holders of record. In addition to the mailing, the notice is published for 5 weeks in a local paper. Next slide, please. Depending on the county, the sheriff may also post notice to the property, although it's not required. The owner may request a cure statement no later than 50 days prior to the sale date. The district bid is comprised of the full amount of the debt is owed, and the property would then be, if it actually gets to that point, it's then auctioned off to the highest bidder. Next slide, please. Upon the sale of the property, the foreclosure of the district lien extinguishes all junior liens. The lender may cure the owner's default and retain their right in the property because, again, they would otherwise be wiped out. Junior lien holders may also redeem following the sale to obtain title to the property. If the property is sold by the sheriff, there may be overbid funds that go to junior lien holders, and then anything after the lien holders are paid off would go to the owner. And then if any overbid funds are not claimed by the lien holders, the prior owner can get those monies as well. Next slide, please. Impact of bankruptcies on foreclosures. Next slide. During the bankruptcy, an automatic stay and nothing happens. The property just sits and languishes. The property just sits with no action being taken against it. I apologize. Upon discharge, an owner's personal obligation for the pre-bankruptcy debt is forgiven, but the lien on the property still remains. So the property is still responsible for the indebtedness, even if the owner is not. Upon dismissal, you can collect or foreclosure continues. Next slide, please. Chapter 13, again, you have the same stay. And if the owner enters into a qualified payment plan, it'll take 3 to 5 years to pay the district off. Next slide, please. And there you go. I think I got in there under 10.
That was perfect, David. Well done. All right. I'm going to go ahead and stop the screen share so we can all see each other. Thank you so much for that. So we do have a few minutes, about 5 minutes here for some questions and answers. And just a reminder that David's role is really to provide some foundational education. And so he was invited to share expertise. He'll be staying on during our facilitated discussion, but he is not going to offer any personal opinions during the Q&A or in the discussion. But we may phone a friend and ask him to weigh in on technical questions as they may come up. So before we begin with our facilitated discussion, are there any technical questions that members of the task force have for our speaker? Yes, Brian, I see you have your hand raised. Please go ahead.
Thank you. Let me make sure I got it off of mute. First of all, David, I just wanted to clarify a couple of things. I don't know how many people on this task force are that familiar with the HOA super lien versus the Metro District perpetual lien. Can you clarify the difference between the super lien and which my understanding is the lenders usually pay off the super lien only in HOA foreclosures, but First Deed of Trust, that would be a lender, as
Right.
opposed to the Metro District case, they almost always pay it off because otherwise they get wiped out. Can you explain how that super lien would work? I think that would be useful.
Absolutely. Thank you very much. An excellent question. A super lien is the HOA's lien is prior to all other liens except for tax liens, existing liens prior to the recordation of the declaration, and first mortgage liens to the tune of 6 months. So the association actually comes in for position when it forecloses from first position for 6 months, second or third position in the event of a deed of trust for the balance of the assessments. Now, what'll happen is, as you point out exactly, a lender for an HOA foreclosure will only pay the 6-month super lien because that protects their interest in the property, where the district forecloses from a first priority, and if the district is not paid in full, the entire lien is wiped out. Correct.
And if I could also ask one more question. In the last several years, the legislature has adopted a number of protections for HOAs under Kiowa. I'm sorry, for homeowners under Kiowa, in terms of the collection process, in terms of restrictions on the HOA's ability to foreclose in certain kinds of circumstances. For example, for fines. Do any of those apply to metro districts? And can you explain the impact that might have on homeowner rights in a metro district fee action versus in an HOA fee action?
They do not apply. Now, it's with just going straight with the law. They do not apply, and there are none of those protections established by law that you have in the Colorado Common and Sternish Act when you foreclose from an association position. So a metro district can still theoretically foreclose for fines, still theoretically foreclose for late fees, penalties, interest, or other things that don't remain unpaid, because again, all of that gets wrapped up into a tax lien.
Okay, thank you. That's all the questions I had.
Great. Thanks, Brian. Christopher Elliott, I see your hand raised. Go ahead.
Yes, thank you. Just a technical comment. It's been our experience that not all jurisdictions that approve the formation of a metro district will actually allow fees. And there are some that don't allow fees as a part of the operation of the district. I just wanted to let everybody know that.
Great. Thank you, Christopher. Representative Parenti, I see your hand is raised.
Yes, thank you. My questions are along the same lines as Mr. Matisse's. We were going very fast, and so I was taking notes and got maybe just a little bit mixed up and wanted to clarify. So at one point we said that Metro District tax liens are superior to all others. And
Yes,
then another point we said, but they don't get repaid in front of other forms of tax debt. So could you just clarify which of those statements was most accurate, or like how those work? Because-
it's based on priority of the delinquency. If I
Right.
fail to pay my property taxes in 2021, that goes delinquent 2022. That I don't pay my district tax fee, whatever, in 2023, that property tax would remain because it's superior in position of time.
You're gonna have to say that to me in some other words. Sorry.
Right.
So superior to all others, are you saying except those that have been issued at a previous date?
Issue and become delinquent. Yes.
Okay. So time of delinquency is actually the most superior of all factors, and then
Or
Metro
tax
District
liens, yes.
taxes are the highest of the other categorical. Is that
Well,
what you're saying?
again, I want to be real careful with that, because if my district lien becomes due and delinquent and I don't pay it in 2022, and then I fail to pay my 2022 taxes in 23 because taxes are paid a year in arrears, then the district lien is superior. So it's based on the delinquency date for tax liens. It's based on the delinquency date.
Okay. I think I understand. Thank you.
Thank you. Jennifer, I see your hand raised. Natasha, I see your hand raised as well. So we'll start with Jennifer. We're going to have to try to keep it brief because we want to move on to the discussion, and then we'll get to Natasha.
Sure. Yes. Thanks, Sarah. Thanks, David, for joining us. Quick question. Are you familiar with the process that occurs before an account is turned over for collection through the foreclosure portion of it, as far as communications with homeowners regarding the delinquency of the fee and the nature of it before it actually starts that foreclosure process?
It is being before it's turned over. I know we advise our Metro District clients, much like we advise the association clients are required to do it. The Metro District clients, we advise them to do it much the same way to make sure that all of those are out. But there is the district statute does not require as robust notice as the HOA statute.
Correct. So thank you. So maybe let me clarify my question a little bit. Is there a pattern that you see as far as what type of communications are made with homeowners before you file the foreclosure action?
Robust. Just from the very beginning, even once, assuming the district just sends out minimal notices, when it comes to an attorney, the attorney must in turn, since the judicial foreclosure, send out the Fair Debt Collection Practices Act notice, which offers a 30-day notice right there to dispute the debt and validate the debt. And then you'll have to go through the service of process. You have to go through the notice procedure that way, and they get personally served. If you can't get personal service, then there's publication and now requirements to do more, as the court has stated.
Thank you. And then just one other question, Sarah, let me know if this falls outside the boundaries of what we're allowed to ask. But my question is based upon your experience for how many foreclosures actually go to sale where the home is taken by the district versus starting the process and having it resolved during the process before that actual sale occurs.
Is running the numbers I can only speak to my office. We had one in 10 years.
Okay.
It's normally, as I mentioned, the lender will pay it off because they fear losing their entire interest in the property. So the lender will pay it off, and then it becomes part of the indebtedness through the first mortgage or for the deed of trust.
Wonderful. Thanks, David. Appreciate it.
All right, Natasha, I had your hand up. And I know I see some other hands up. So we're going to get Natasha's question, but I think we're going to try to move into the Q&A. And certainly as we have technical questions come up, David has agreed to stay on so that we can get some clarification as these questions may come up in our discussion. So Natasha, please go ahead.
I had 3 questions in reviewing the materials and listening today. Let me just start with the key one. And I know maybe Ms. McGeady and Ms. Tanaka can also speak to this, but David, when so many of the districts are formed as a master servant district. So the master is providing the services. Those are typically developer controlled with no residents. So how does that work logistically? They're assessing a fee. They're the ones providing the services, but the homeowner is in a tax district that has no input on those fees. And I think we've discussed in our prior meetings, there's some issues on transparency and control. How does that work between these districts then? If you have which district is levying the fee, which district is foreclosing, and how would you foreclose on a property that's not in your district? It's in the tax district. So could you address how the mechanics of this master servant setup work, please?
I have not been in that realm for a while. Now, I can tell you when I was in that realm, how it worked was the developer will set up a master control district, or let's call it a control district, and then we'll enter into an intergovernmental agreement with the service district. And then it is actually the service district that is doing all the actions, but the service district is operating through the intergovernmental agreement with the control district. And that is probably a better question for your developer district attorney.
If I could just follow up, I have not seen that situation. I am seeing the situation here in my valley many times over, and in the Front Range and other mountain communities, where it is solely the master district that provides the services. The servant districts simply provide the tax funding. So I think it creates some concern for me of the control of the ability to set those fees, what expenses are being paid, and the transparency. I'll save my other two questions for later, but I really do share the concern from Representative Parente and from Mr. Matisse that we are now looking to circumvent the legislative protections on HOA. I don't like the idea of the homestead exemption coming out here. So I think there's some significant consequences here. I also am curious how lenders would take. Does that force homeowners to have higher interest rates, or lenders less interested in borrowing to people, lending money for people inside a metro district? I think that has a waterfall effect, and I don't know if you've seen that.
It's anything I say would be my opinion, and I was told not. So
Thank you, David. Appreciate that. All right, so we are going to go ahead and move into the facilitated discussion. So we have, just as a reminder, our objective today and at every meeting is not to necessarily reach consensus on all of our topics, but to ensure that everyone has an opportunity to contribute and share their expertise and experience. So we'll be leaning on those meeting norms as we have our discussion, but we're going to start with our first of our three core questions. So as it relates to this topic of foreclosure practices, what is it about current practice or policy that is working particularly well, or high functioning, or otherwise very effective? And so we'll go ahead and take that feedback from folks on what's working well with our current policies and practices around foreclosure.
This is Marianne. I think from the district's perspective, which is where we sit most of the time, the process is working well. I think just like Jennifer, I think was leading to in the path of her questions, and David is kind of hesitant to assert his opinion. I could assert mine, which is I have not seen any in our practice go to property sale. Actually have never seen even the foreclosure process go to court to a judgment in all the districts that we represent. Usually it's a conversation, and the idea that there's due process that's required, so notice and communication to the residents, and an understanding of what the disconnect is and why the fees aren't being paid. There's a process there that's already in place. So I feel that the statutes are working well the way they are. I think if there's issues with how they're working that we need to address, would like somebody to articulate those so we can specifically address those issues. With regard to Natasha's comment, I'm a little confused because the statutes say that a district only has the power to enforce covenants within its boundaries. Districts do contract with each other to try to coordinate that enforcement, but you in the circumstance she was describing, where you have one district that is trying to set fees and enforce them on another district, if there's an agreement in place and that agreement isn't terminated, then that kind of service can be provided. But if you have a resident controlled district and they don't want another district enforcing their covenants anymore, then they just need to assert themselves under the statute and say, we only enforce within our boundary. You can only enforce within your boundaries, and we're not contracting with you anymore. So I'm a little confused about what the issue is.
So Natasha, perhaps we can bring that back up when we talk about what's not working well, and maybe we can have more, we can flesh that out a little bit more. I did see some other hands raised. So Brian, please go ahead.
Yeah, thank you. I would agree, first of all, in terms of what's working well with David Furman's comment that generally in Metro District liens and foreclosure processes, it has an advantage over HOA foreclosures because of the priority. Lenders generally step up and in my experience, pay off the lien, and that is the Metro District. In the case of HOAs, you have only a 6-month super lien that they pay, and often the foreclosure process takes a year or more, which means that in cases of a deficiency on the first deed of trust, in many cases, the HOA winds up having to write off a significant portion of their debt because the process takes more than 6 months, takes a year or more, in which case fees aren't being paid, assessments aren't being paid, etc. The second thing I think that works fairly well with Metro districts is that, and I think this is something that maybe Jennifer Tanaka was alluding to in her questions of Mr. Furman. While HOAs have protection, HOA residents have protections of Kiowa that are statutory and that have been adopted. Metro District best practices, and I want to emphasize that, not required by law, but best practices typically require notice to homeowners prior to initiation of foreclosure. Once again, it's not required by law because Metro Districts are not subject to Kiowa requirements, such as all the notice requirements that have been required, but nonetheless, best practices, they often do that.
Great, thank you. Thank you, Brian. All right, Jennifer, I see your hand raised.
Yeah, and I'll be brief. I know we're trying to move on, but I'm going to piggyback on to what Brian was talking about just to provide a little bit more meat on the bones. And he's exactly right. The notices, at least in the best practices, and again, we can't speak for all of the firms out there, but for those that we work with and for the districts that adopt these resolutions, you have several letters that come first from the district manager that say, hey, we haven't gotten a payment. Here's a reminder. Here's a warning letter that you haven't paid. This is another month. The next step is that we're going to turn it over to council. Council then provides another notice before the actual paper lien is recorded onto the property, which is another best practice. It's not something that's required, but most firms do, just so that in the event of the change of title, it's captured during a closing, etc. Then there's a period of time before the lien is actually recorded. And then you have some other letters that go out before it's actually even tendered over to a collection attorney to process through the debt collection practices and then ultimately through a foreclosure. So there are a number of different communications that go out to that property, and it goes not only to the property itself, but also when you look at the clerk and recorder's records, the owner might have a different address. So it might be a tenant landlord situation where maybe the tenant's not paying it, but getting these notices and they're just trashing them. And then the landlord never knows. And then they get this nasty notice. The letters end up going to both of those addresses so that you have the landlord or the owner of the property that is aware of it, as well as any person that would be occupying it. So just to add a little bit more meat on that for the communications that occur prior to foreclosure actions.
Great. Thank you, Jennifer. Appreciate that. All right. So it looks like we've got all of our hands that were raised have been called on. This is a good summary of what's working well. So now's our opportunity to talk about what's maybe not working as well as it should. What is it about current practice or policy that is not working well, it's not functioning, or it's not effective? And so this could be an opportunity to maybe clarify some of those questions that I know Marianne had for some of Natasha's comments. So not to put you on the spot, Natasha, you don't have to jump right in. But this is our opportunity to spend a few minutes talking about what's not working well with current practice. So who would like to go first? You're all being very thoughtful. All right, Natasha, go ahead, jump in.
Well, I'll jump in. I think a few comments stood out to me is while I appreciate Brian's comment that there is due process, I think we underestimate that our judicial system is rather price prohibitive and it's hard for most citizens to participate. It is an expensive process. In terms of, my observations, there are very few boards that I've come across that are homeowner controlled in our valley just recently. I mean, in the district where I reside, the homeowners only took control of a board that was formed in 2003, took control of majority seats in 2016. Down valley, it finally happened for the first time. I also do wonder about some of the controls. If in the HOA world, a declarant can only control for 20 years. Here really depends on the political advocacy. So I think that's one of the downsides. With the comment on the master servant, again, the hitch there is education. This was a new chapter for me. I was not aware of this really broad-reaching foreclosure process. And when I look at the boards that are homeowner controlled, are they savvy enough to know to end any IGAs that grant the master district this kind of control? So those are the things that kind of stand out to me. Would they even be savvy enough to know to opt out? And again, as Brian pointed out, we've spent many years legislating HOA type situations. We don't see those here. And what I'm seeing is a bigger trend where metro districts are trying to push all the traditional design review and everything towards the metro district. Upside, yeah, becomes tax deductible for some folks. But the downside is we're really seeing the very things that the HOA legislation was designed to protect. So many of those are getting pushed to be a metro district expense. So those are my concerns.
Thanks, Natasha. I appreciate that. Brian, I see your hand raised, and maybe you can expand a little bit on what Natasha had said as well.
Yeah, I think I can a little bit. And I was going to comment on one of the things one of the concerns that I have is that metro districts that enforce covenants, they have the ability to foreclose due to a fine that might be insignificant, and because it's a first deed, they take priority over a first deed of trust, and they're perpetual, and I think that's important too. So you could have a metro district lien, lien that was recorded 20 years ago, and that's still a lien that is superior to the first deed of trust on the property. Whereas HOA liens, if actions are not begun to foreclose on them within 6 years, they expire. So one of the concerns I have is that you have a governmental entity here. A metro district is a governmental entity. It has to enforce covenants, and those covenants might include things like architectural guidelines and design review guidelines, what color to paint your house. And so you have someone that maybe paints their house the wrong color, and you have a government telling them what color they have to paint their house, pink versus blue, for example, or something like that. And then they can impose a fine on homeowners because they painted it the wrong color. And that fine can grow with attorney's fees, with costs of collection. It can be as a lien for 20 years or more that encumbers title. And you can result in exactly the same homeowner concerns, or the same concerns the legislator had toward homeowner rights, and that they resolved in Kiowa. Now, I agree that this may be the rare metro district that has these bad practices or that chooses to foreclose for painting your house the wrong color. But the fact is that, especially for in those metro districts where there may be lower income people that cannot pay a fine of $200 or $300 perhaps, that can be very wrongful. There aren't the protections in the Metro District statute, the Special District Act, Title 32, that are in Kiowa. The legislature has sought fit to do so. So you may have the outlier. I mean, just like most homeowners associations, I don't think are abusive in their foreclosure, and they rarely, if ever, foreclose unless there's extremely high amounts of fees that are owed. I think that there may be an outlier in the case of one or more metro districts, or potential for outliers, where they could foreclose on something that is insignificant.
Thank you, Brian. Bert, I saw your hand raised earlier. Did you want to chime in? We haven't heard from you yet, so I want to make sure I made some space for you there.
Yeah, I think that I wanted to second what Brian had to say, and also what Natasha had to say with regards to the fact that we've made a policy decision in Colorado that we're not going to be providing the homeowners with the same kinds of protections who live in metro districts as those who are under the Kiowa. And I think that's a policy decision that needs to be addressed. Obviously, those of us on one of the recommendations that we might be able to make is that, the same sort of foreclosure protections that exist under Kiowa ought to exist for metro districts, or even more. A better, it seems to me, policy decision would be metro districts shouldn't have the power to foreclose at all. That there are other alternative remedies for debt collection that would not make somebody lose their home and still be able to collect the debt that's owed. That's a sort of that's a 30,000-foot view anyway. So
yeah. Well, and I appreciate you teeing up the solutions conversation, which we'll be transitioning to in a moment. So thank you, Bert. Before we move on to that, I did see Jennifer's hand raised. So go ahead, Jennifer.
So I just had actually a question that might be most appropriate for Representative Parenti, just for a clarification question, because of being a sponsor for the bill for our task force. And I'm hearing a common theme that the concerns seem to be mostly with covenant enforcement and design review type HOA similar type services. Is that what the concern stemmed from initially, or does that seem to be the theme that those that are expressing concerns have? It seems like from what I've heard of any of these issues have been related to design review and covenant enforcement, and versus like a water and sewer tap fee, for example. It seems like this is a much different scenario. I just wanted to clarify that, if you don't mind.
Yeah, thank you for the question. Actually, I think the inclusion of metro districts into the bill in this conversation, the creation of the separate task force, was primarily concerning tax policy, governance policy, voting policy, elections, the things that are really unique to metro districts, but acknowledging that there's overlap with these sort of community association problems that also come up in HOAs. And it's why the task forces were structured separately and staggered, so that this body could benefit from the results of the HOA task force, which is also meeting. And I understand that they have completed their at least initial set of recommendations, and we're supposed to hear about those soon. So I do think that there's a place to have the conversation in both task forces, but I certainly would not want this task force to get overly focused on the issues that also relate to HOAs, because there's another task force specifically looking at those. Which is not to say that we shouldn't talk about them at all, because they're absolutely also appropriate to metro districts. I hope that explains.
Excellent. Thank you, Representative. I think that's actually really helped clarification for a lot of us. So before we move on, I just want to put one last call out. Is there anyone else who would like to weigh in, perhaps folks who haven't spoken yet, on what's not working well, even if it's saying ditto to maybe a concern that's already been voiced, just for the purposes of the report, so we make sure that we're being thorough and giving everyone an opportunity to speak. Yes, Representative Parenti.
Thank you, Sarah. I think I would just add to this, maybe a repeat of some of what we discussed in the last task forces, which is just simple homeowner education. When it comes to these lien policies and who's got superiority and so forth, I'm still a little bit confused, even having listened to this conversation, and I'm sure that homeowners would also, most homeowners would feel the same way. And so I think to the extent that we can provide better education, better disclosures to homeowners around these policies, I think that's always helpful.
Excellent. Thank you, Representative. All right. Well, we're going to go ahead and transition to solutions mode. This is our chance as a group to reflect a little bit on some of the concerns that have been raised and have a good, robust conversation around what specific, measurable, and implementable recommendations for improvement could be made that might alleviate some of these concerns that have been raised today. So would love to hear, I know we've already talked about it a little bit. Bert, you did a great job saying that there's some recommendations to make the process a little better, but we'd love to hear from everyone now on what sort of recommendations you could offer for improvement that we can capture in this report. Yes, Jennifer, please go ahead.
Sure. Sorry, I was trying to wait to give others an opportunity because I'm sure you're tired of hearing me speak. So, but one idea, the reason I was asking some of the questions I was asking is because one idea that that could be a potential solution to the concerns relating to specifically covenant enforcement design review and the potential of a house being the wrong color and having it be silly for somebody to lose potentially their home over that. I could not agree more. One solution that we have when it comes to water and sewer in particular is we have the ability to certify delinquent fees for collection with taxes the following year. So as opposed to turning somebody's water off, or which is a legal way to handle the situation, or as opposed to putting a lien on that property and going through foreclosure, that is an option that water and sewer districts have. And perhaps that would be something that could be done here. Certainly districts, they're not for-profit organizations. They have costs that have to be covered, and, unpaid fees is certainly a concern because people that don't pay fees, it results in others having to cover that delta, which isn't a fair solution either. And so if you have a property that's delinquent, perhaps rather than starting that foreclosure process, then they just get certified for collection with taxes the following year. That way it goes through the normal property tax procedure as opposed to a court procedure. That would just be something to toss out there.
Is there anyone else who would want to piggyback off that or offer something new? Brian, I see your hand raised. Why don't you go ahead?
Yeah, I'll piggyback off of that. I agree in terms of efficiency with Jennifer Tanaka that certifying Metro District fee liens as for collection via the property tax by the county property tax procedure would be efficient and effective. The concern I have is that you still have the same concerns over whether a lien that is, or a fine that is being imposed for a covenant violation now becomes a property tax lien that the county will then presumably collect on, potentially through a tax lien sale, which would occur in November. And once again, the homeowner runs the risk of either having a high priority tax lien on their property that needs to be paid with all of the additional interest, the additional collection costs, et cetera, for something as minor as a fine for a violation of the color of your house or something like that. So that's a concern I have. So there's pros and cons there. I guess one of the questions is that I would ask, and one of the solutions perhaps that I would ask is, maybe it's better that we not allow metro districts to do covenant enforcement. Covenant enforcement can still be done through either separate from the metro districts, from individual homeowners, or individual homeowners could create a homeowner association independent of the metro district themselves. Smaller communities, for example, that have covenants recorded, but they don't have HOAs, they do that all the time. So there's a real question as to whether a government really should be deciding issues like aesthetics and then having the color of the house, design review, things like that are very subjective, and be able to impose high priority liens and or foreclosures because of those.
Thank you, Brian. Let's see, Chris Elliott, see your hand raised. Chris, did you want to go?
Sorry, I have trouble with my mute button there. I appreciate what Brian has just said, but I think it's a dramatic jump from the discussion of whether or not foreclosure as described for a metro district is a solution versus throwing out in its entirety the opportunity for a metro district to enforce covenants. I think this is an issue that rises to the level that it probably requires its own distinct conversation when you contrast and compare what Metro District can do versus an HOA and all aspects of enforcement of design review and covenant enforcement between a district and an HOA. It's pretty significant. We fall on the side of letting Metro Districts enforce it, not because there's an advantage to us as developer to have that opportunity, but because it's much more efficient, it's much more transparent, and it's much more reasonable to the homeowners who live within those communities. So I wouldn't want there to be a conclusion that the way to solve the foreclosure issue is to really stymie or inhibit districts from providing that enforcement opportunity.
Great, thank you, Christopher. All right, I see several hands raised. So I just encourage everyone to try to be brief so that we have time to hear from everyone. Commissioner Odoricio, I saw your hand raised. Are you? Okay, great.
I was just asking, to address Brian's question, is there a difference in the standard for that addresses the risk of subjectivity, whether it's an HOA or a metro district? And that might be in the next speaker where they go through all the different comparisons between the two. But I can tell you, anyone who's been on the wrong side of an HOA doesn't feel like there's less objectivity. There's less objectivity in an HOA than there is in a metro district.
And that's a great point. We are going to be talking about the differences between HOAs and metro districts with our next set of speakers. So we can get into that a little bit more there. Natasha, I see your hand raised.
Yeah, the three coming into this discussion that already stood out to me, I do hear Brian's comment. I have to concur, and it was said elsewhere, that I'm not sure the foreclosure power granted by a governmental entity, especially when the legislature has worked so hard to protect homeowners with HOA reform. If you're going to go down that path, I think Brian brings up a good point of we should at least include a dollar amount that a district can only foreclose, not for a de minimis fine of you failed to shovel your driveway or you painted your house the wrong color. There should be a threshold at which they can take action and not accruing any interest or penalties on top of it. But is there a threshold fine? I think if we're going to allow it, that would have to exist. And if one is going to allow it, the one that concerns me the most, because it is the predominant form that I have seen, is in the master servant setup, that even if there's an IGA, we cannot allow foreclosures. I think there are so few servant districts that are homeowner controlled, and the disparity of what Representative Parente discussed of understanding of the powers. So again, I don't think this is the right place in the mechanism to foreclose. I don't think it affords the same protection. If we're going to do it, I would want to see those two protections. There needs to be a threshold dollar amount when a district can enforce in certain maybe subject areas, and then certainly not in a district that has a master servant set up. I think those need to be carved out because the risk of abuse is way too high.
Thank you, Natasha. All right, Representative Parenti, go ahead.
Thank you, Sarah. I would just offer that if for instance the task force does not want to pursue the separate covenant duties as Mr. Matisse discussed, although I think it's a valid conversation to have, similar to Ms. O'Flaherty's comments, one thing that we could do is just ensure that all of those protections that have been passed previously for HOAs would then also apply to the fees and the covenants related issues that are governed by Metro districts.
Great, thank you, Representative. All right, well, I think we're going to be able to wrap up this conversation. However, I know that there's some folks we have not heard from, so I want to make sure that we're creating that space and time. If there are some of you on the call that haven't had a chance to speak yet and you would like to just offer, you know, your own perspective or 2 cents before we wrap up, I just want to open that up to others on the group that have not had a chance to speak yet. And if you don't have anything to add, that's fine, no pressure, but I do want to make sure we're creating that opportunity. All right, I'm not seeing any hands raised. That's wonderful. And I think we've had a lot of momentum already on this conversation, and it sounds like people are really ready to dive into Kiowa and HOAs. So we're going to go ahead and start that next topic. So our next official topic, and again, this was one that was defined within the legislation, is the process to transition from a metropolitan district that enforces covenants and collects assessments into a common interest community. We have 2 speakers who are going to be sharing their expertise today. The first is Elizabeth Ortiz. She is a shareholder with a law firm of McGeady Betcher, and she manages an active special district law practice as well as serving on the firm's executive committee. Elizabeth has been practicing special district law since 2012 and has been involved in the practice area since 2004. Elizabeth enjoys the challenge of working in special district law because it allows the opportunity to build relationships between the public and private sectors, and to be creative with solutions to a new and changing industry environment, and to work with professionals from many different backgrounds and entities. Prior to her time with McGeady Betcher, Elizabeth worked as a trial attorney, litigating products, liability, and personal injury cases on a national basis. She is a frequent speaker and writer on topics surrounding special districts. She's joined today by Tricia Harris, who is counsel at WBA. Her practice focuses on representing metropolitan districts as general counsel, as well as representing the firm's community association clients. Ms. Harris also draws upon many years of experience representing community associations to assist developer clients with drafting covenants and governing documents for new communities. Ms. Harris brings to the firm almost 2 decades of experience in representing homeowners associations in the state of Colorado, as well as her experience with metropolitan districts and development matters. She's taught numerous classes and seminars considering a myriad of legal topics related to homeowners associations. She earned her JD from the University of Colorado School of Law and her bachelor in marketing from Colorado State University. So wonderful, ladies. I appreciate you joining us for this presentation. And I believe, Elizabeth, are you going to share your screen for the presentation?
I am.
Wonderful. Please go right ahead.
All right, can everyone see that? Thumbs up. All right. I will start out by apologizing for my voice. I promise you I'm not talking to you from underwater, recovering from this crud that has been going around. Myself and Trish Harris will be speaking today we're going to start out with a comparison between metropolitan districts and homeowners associations. Akin to what David was saying when he began his presentation, this is a topic that could take several hours. We realize that some of these items have been topics of prior task force meetings, and some are topics that will be discussed in future task force meetings. So we will be going quickly, but are hoping just to provide a snapshot comparison between the two. First is the purposes of a district versus a homeowners association. Special districts can provide infrastructure and services to new and existing developments that county and municipal governments are unable to provide. Special districts can serve as a financing vehicle for the provision of public infrastructure to new and existing developments. And special districts possess powers and privileges of governmental entities that private developers do not otherwise possess. I'll turn it over to Trish for
Thank you. And good afternoon, everyone. Thanks for having us here. Yeah, and so for an HOA, really the primary purposes of an HOA are number one, maintenance of common property that the HOA owns, such as pools, parks, clubhouses, those sorts of things. Preservation of property values through covenant and rule enforcement, uniform aesthetics through the community, design review that was touched on previously. I see a lot of associations really working toward building that sense of community as well through social events and those sorts of things. And they also provide services like trash removal, snow removal. They may maintain private improvements on owners' lots. The association may be responsible for maintenance of the front yards and those sorts of things.
Next, very high level again, how is a district different from an HOA? Special districts, as you've heard several times, I know, but are quasi-municipal corporations and political subdivisions of the state. So they are governments. They're subject to Title 32 of the Colorado Revised Statutes, open meeting laws, budget laws, audit laws, CORA, and other laws governing public entities. They operate as a form of local government, and all facilities that are owned or financed by the metropolitan districts must be kept open to the public. So not just the members within or residents and owners within the districts themselves, but the public as a whole.
Yeah, and on the HOA side, HOAs are private corporations. They're typically established as nonprofit corporations in the state of Colorado, and they're governed by statutory provisions through both the Nonprofit Act and the Colorado Common Interest Ownership Act, otherwise known as Kiowa. Those are the two main statutes that really kind of come into play when we talk about HOAs. But a lot of the detail of it and guardrails too on what they can each do come from their governing documents. So they're covenants or bylaws, articles of incorporation. Contrary to districts, associations can, and often it's only their owners that can use their facilities, and it's only their owners who are members of the association. Again, typically responsible for covenant enforcement, and like in the case of townhomes and condos, they're responsible for maintenance of exterior of the buildings and those sorts of things as well.
So again, high level recap, metropolitan districts, special districts are created pursuant to Title 32 of the Colorado Revised Statutes, which is commonly known as the Special District Act.
And associations are created pursuant to Title 38, again, the Colorado Common Interest Ownership Act. Just a note, Kiowa applies in its entirety to associations that were established after July 1st, 1992, for what we call pre-Kiowa communities, those created prior to that. Specific provisions of Kiowa apply, so we always kind of have to look at the statute to see if it's pre or post-Kiowa and what might or might not apply to any particular association.
So services provided, metropolitan districts are a special district that provide at least two of the services listed: fire protection, street improvements, water, transportation. In addition, Title 32 provides the authority for districts to operate in lieu of or in connection with a homeowners association. And again, property owned and maintained for the use and benefit of the public.
Yeah, and the services provided by an HOA, in addition to kind of what we've already talked about as far as, maintenance of common area and those sorts of things, they collect assessments from owners. That's how they, fund the services that they do provide, and enforcement of the rules of the community. And again, the property that's owned and maintained by the association is for the exclusive use of the members of the association. So, the public can't come and use the pool at, Shady Acres HOA.
And Elizabeth and Tricia, we're about at the halfway point of our presentation.
Perfect. Okay. Formation is also very different. For metropolitan districts, it starts with the submittal of a service plan to the jurisdiction in which the property is located. There is a petition for organization that is filed with the district court. At that hearing, The court, we hope, orders an order calling election. Once that order is issued, there is an organizational election on both questions of organization and debt. Elections are held under the Title I, so just like any other state governmental election in the state of Colorado. Election results are certified. Once those election results are certified, a court motion is filed with the court to declare the district organized. Once that order is issued, that is recorded upon the property, and the district holds its organizational meeting. So it starts with, a petition from landowners. Doesn't always have to be landowners, but within the district boundaries, through jurisdictions, through the district court, and through an election process.
And on the HOA side, those really, an HOA is really formed by the recording of a declaration, which is done by the declarant or the developer early on in the process. So that's recorded in the county where the property is, that's going to be part of the association. And then that gets indexed in the clerk and recorder's records. There's also a recording of a plat or the condo map if it's going to be a condominium association. And then also kind of in conjunction with that, there will be a filing of the articles of incorporation, which then creates the association as the legal entity of a nonprofit corporation in the state of Colorado.
For the documents and governing items that metropolitan districts operate pursuant to, it's that service plan that we just spoke of. Again, open meeting laws, public bidding requirements, public budget laws, public audit requirements, statutory disclosure of conflict requirements, as well as TABOR.
And then for an association, again, in addition to Kiowa and the Colorado Revised Nonprofit Corporation Act, which really kind of deals with the association governance side of things more than anything, associations are really driven by their governing documents. Again, the covenants, the articles, bylaws, any rules and regulations, design guidelines, the governance policies that are listed here. Those are actually 9 policies that we colloquially call the SB 100 policies sometimes, that are required actually by Kiowa for all associations to have. And they cover 9 different topics that associations are required to have in place.
Who can vote, who are eligible electors within a metropolitan district. An eligible elector is defined as anyone who at the designated time or place is registered to vote in the state of Colorado, who is a resident of the special district or the area to be included in the special district, and who or whose spouse or civil union partner owns taxable real or personal property located within the boundaries of the district, regardless of whether or not that person resides within the district or not. So what that all comes down to mean is any person registered to vote in the state of Colorado who is an owner or spouse or civil union partner of an owner, or who is a resident within the boundaries of a district, is eligible to vote and serve on the board of a metropolitan district.
And on the association side, it's really driven by the governing documents. Typically, we see where the governing documents require an owner, that all owners are entitled to vote. Usually it's 1 vote per household. So if you've got a husband and wife that own together, they collectively get 1 vote. They don't get 2 votes. And then typically it's an owner within the association, those owners who are eligible to be on the board of directors as well. Sometimes we'll see provisions where, they have to be in good standing and, current in payment of assessments, those sorts of things. But typically the eligibility to vote and the eligibility to be on the board turns on being an owner within the association.
Elections, metropolitan districts have regular directors elections in May of odd-numbered years. Organizational and debt elections can be in May of odd-numbered years and November of each year. Again, as discussed, it's under Title I, the Uniform Election Code, as well as TABOR. The other thing to point out under metropolitan districts is because of the staggered election period and the every other odd-numbered years, There is no declarant control period. Tricia will get into this a bit when she talks on her column here. But once you are an eligible elector within the district at any point that a seat becomes available, either through a vacancy or an upcoming election, if you meet those requirements, you are eligible to run for such a position.
And on the HOA side, elections really are governed by Kiowa and the governing documents. You know, the governing documents, typically the bylaws will be the ones, the document that tells us what the, you know, term of office is for board members, you know, when we hold elections and those sorts of things. But as Elizabeth said, under Kiowa, we do have a declarant control period where there's a process where it's phased in to homeowner control of the board. So when we've got 25% of all of the units that can be created that have been sold to owners other than the declarant, then we have to have at least one member of the board, not less than 25%, be elected by the owners. When we get to 50% of the homes sold, then we go to 33 1/3% of the board has to be homeowners elected, or members elected by homeowners other than the declarant. And then when we get to 75%, that's when a majority of the board has to be homeowner elected individuals. So there is a very kind of structured phasing of turnover from declarant to homeowner controlled on HOA boards.
Governance, metropolitan districts are governed by a 5, typically sometimes 7-member board of directors. Again, any eligible elector is eligible to serve on the board. Directors elections and debt elections, as we've discussed. When you are elected or appointed to a metropolitan district, you are an elected official.
And on HOAs, I've kind of touched on most of this already, so I'll just go through this quickly again. Kiowa doesn't specify the qualifications for board members. That's really driven by the governing documents, as well as the number of board members. Again, sometimes they'll say you have to be in good standing, but typically at least the baseline is you have to be an owner in the community. HOA board members are volunteer board members. Typically, they're not going to get paid. The bylaws may say they can get, you know, some, you know, amount, but typically we don't see HOA board members getting paid. 99.9% of the time, they're volunteers.
They also have different methods of raising revenue. Metropolitan districts, mill levy revenue collected by the county treasurer, fee revenue collected by, it depends, but, you know, district management, district accountant.
And on the association side, their ability to raise revenue is really driven by Kiowa and their governing documents through assessments. Regular special assessments really are the main ways that we see associations raise revenue to provide the services that they do.
And just wanted to make sure we're moving along because we are at time. So if we can,
we have a few more, and we can go ahead and these. You know, a big item, and I know we talked about, or you all had a meeting on this on the last meeting, the annual meeting and membership meetings. Metropolitan districts are now required to hold annually with proper notice annual meetings where these 3 items, I won't read them to you to save time, are discussed. Those are the only items that can be discussed at the annual meeting for districts.
And on the association side, they are required to hold an annual meeting. That's typically when their directors get elected. And there's certain notice requirements in Kiowa, not less than 10, not more than 50 days in advance. And the time and place of the meeting has to be provided in any agenda items.
Document production and conflict disclosure, metropolitan districts again are subject to CORA, Colorado Open Records Act. They are also boards are required to disclose with the Secretary of State at least 72 hours before every meeting any known or potential conflict of interest.
And on the association side, Kiowa has a specific list of documents of the association that our owners are entitled to inspect. So it's not, the whole gamut of every record of the association. And then Kiowa and the Nonprofit Act really drive what constitutes a conflict of interest and when that has to be disclosed. And, one of the things that I think we were kind of asked to discuss a bit was, transition of district into a common interest community and, application of Kiowa to districts. And as we kind of just pointed out, Kiowa does provide for certain procedural and other requirements for associations that, may or may not fit with districts and may result in some ambiguity and tension. For example, like the disclosures that a district has to make under the Special District Act are different than what an association has to do under Kiowa. Their powers are not exactly the same. Meeting provisions are not exactly the same. So I think that was kind of seen in our kind of side-by-side comparison. So.
Then we've reached the end of our slides.
And that's it.
Right. We do have a few minutes for question and answer from folks on the task force. If you have a technical question for our speakers, please go ahead. Jennifer, I see you jumped right in. Go for it.
Thanks, ladies. Appreciate your time. So two questions for you. One, if you can touch on the elections. You touched a little bit on elections for districts and then at HOA, but I think kind of maybe touching on the local government election law might be helpful. And then also on the last slide, I think the biggest takeaway is if a district were to convert, you obviously don't have the public benefits that you would do with the district, like the power of taxation, the ability to issue tax exempt bonds. Is there any expansion upon those types of pitfalls? Should that be something that would be explored?
Elizabeth, I'll let you answer that first one.
Okay. So for Metropolitan District elections, for directors elections, they are held every other year, odd years in May. And so if there are, when at the organizational election, there are staggered terms. So we are now back to a certain number at 4-year terms and a certain number at 2-year terms. And so as the years progress, if there is any seat that is up, whether it be a 4-year term from that original period or a 2-year term, any eligible elector at that time is eligible to run for and also an eligible elector to vote in those board elections. In addition to that, if there are any vacancies that are opened in between the time of those odd year May elections, any eligible elector at that time is eligible to be appointed to the board of directors. Again, immediately upon moving into your home, whether you are an owner of that home or residing in that home, as long as you are registered to vote in the state of Colorado, you are a voting member within a metropolitan district and eligible to fill any vacancy or run for any seat. Vacancies are appointed until the next regular election. So even if you are filling a seat for, let's say, a 4-year term, if you're appointed and the next regular election is the following May, you are appointed until that next regular election, at which point you can run again.
And just to kind of piggyback on that too, Elizabeth, those are highly regulated by the local government election law. That's a statutory election law that applies to other local governments and is overseen with the Secretary of State too. Is that correct?
That is correct. Those are full mail ballot elections run under Title I.
Thank you.
Sure.
Any other technical questions for our panelists before we move into discussion? Yes, Brian, go ahead.
Yeah, I just have one question because I thought the topic of this was going to be the process to transition from a metro district that enforces covenants and collects assessments into a common interest community. And from what I'm hearing from the presentation is that they're two different entities, and one shouldn't transition into another. But I just want to I guess a technical question for one or both of you is, there are some metro districts, in fact, there are quite a few metro districts that don't actually provide any services except to finance the initial infrastructure. And then when the bonds are paid off and there's no more debt, pursuant to the service plan, those metro districts are supposed to dissolve. So is there any reason, or better yet, number one, is there any reason why metro districts couldn't dissolve and transition the enforcement of covenants into an HOA that would then be created? And number two, what would that process be of doing so?
So at the
Yeah,
risk here, yeah, sorry, go ahead,
I don't
Tricia.
know if, I was going to say, I don't know if this, gets into the opinion realm of things. But, if there's an HOA that's already in place, I could see it happening through, an amendment to that district declaration that's already in place. If there's not an association that's already in place, if the district is dissolving, an association, yeah, I guess it could, if all of them are in agreement. But I don't want to stray too far into the opinion category. So.
And Tricia, you were breaking up a little, so you might want to just go off camera, and that might help with the audio quality. So, and I want to get to Representative Parenti, because I think this is a really great transition to that question, because this was a wonderful summary of the distinctions between those two. But the real question at hand is that process to transition from a metro district to a common interest community, or an HOA. And Tricia, I think you gave a good answer to that, but I do want to just expand on that. And Representative Parenti, could you also just clarify a little bit what your primary interest is? Did we lose Representative Parenti? I don't see her on screen.
I'm here.
Okay, good. Okay.
Go ahead and just pull up the statute. So actually, I'm going to defer to my colleague, Senator Gonzalez, who also had her hand raised. While I pull up statute, I want to give her a chance to speak.
Great.
Thank you, Representative Parenti. I just will, one of my questions, in a technical question as it pertained to the last slide that we were just reviewing, is whether Metro District directors can vote to change their term limits that would exist for other constitutionally elected officers, as in state legislators, or vice versa, or et cetera. So that's my technical question.
And Elizabeth,
a bit outside of the topic, but yes, there is the ability to have election questions that relate to term limits, but I wouldn't want to get into that in too depth today.
And I just want to point out that we have dedicated time in our upcoming meetings to talk about governance policies, which includes voting in elections, as well as tax levying authority and practices. So the conversation today is just focused on that language around transitioning from the Metro District to the HOA, and what that process and procedures look like. So Senator Gonzalez, was there another point that you wanted to make? You're good? All right. So Representative Parenti, I know you were pulling up the legislative language. So do you want to just add a little more context to help guide the conversation?
Yes, absolutely. So I'm just going to read from legislation here. The task force shall also examine the process by which a metropolitan district could transition from a metro district that enforces covenants and collects assessments into a common interest community governed under effectively Kyle. And so I think this goes back to Mr. Matisse's comment earlier about, separating those sort of covenant activities from the metro district itself into, a separation, so that the metro district would be one really focused on the debt and the kind of the administration of the debt, and those sort of infrastructure services provided by the Metro District, and then have that more governance, community enforcement separate. And what would it take? That's the question, to branch that tension that our speakers spoke about. What would it take to breach that tension? What would we need? Is that allowed under current law? If not, what we need to change? Right, that's really the question. That I think that was the intent. Yeah, and I'm not sure we're quite there yet with the information we've been given.
Excellent, excellent. All right, that's really helpful clarification, Representative, and you would know because you helped draft the language of the bill. So thank you. All right, so with that, Tricia and Elizabeth, can you take a stab at answering that? I know we have some other folks on the call who might be able to, or the Zoom that might be able to answer that, but Tricia and Elizabeth, I'll toss it to you first.
Yeah, and you know, as far as transitioning a district to a common interest community and kind of having that separation, we've got in the statute that districts can provide covenant enforcement and design review services. So if we've got a district that's already doing that under their own, what I call a district declaration, to transition that into a common interest community really would take, and I may be straying into opinion here, amending that declaration to make it a common interest community as defined in Kiowa. And it's a very technical definition. And so, and that's where, if we do that, then that declaration that now has a common interest community is subject to Kiowa. And then that's where those differences and that tension comes in between a district that, you know, is governed under the Special District Act, its Service Plan, the Open Meetings Act, versus Kiowa and the Nonprofit Act. And those differences there come into play. Does that help?
I think it also has to do with a method of the timing and when you're talking about when these things convert. To go back to Mr. Matisse's statement, if it is a point at which all of the debt has been repaid and the only obligations left for the district is to operate and maintain improvements, and the community members want to have an HOA take that over instead of a district, that would have to be a vote of the members within that. I think if it's conversion into an HOA, there, I guess I should say, there is rarely, if ever, have I don't believe I've ever seen anything that limits in any service plan the community from forming an HOA in addition to a district. So I will leave it there. I see Marianne's raising her hand.
Yes,
So.
I just messaged her, Marianne, you're next.
I was gonna say, I just don't know if you're seeing my raise hand. I just, what the technical questions, I think we're kind of skirting around them a little bit because there's a couple of pragmatic issues here, and I asking, you know, the experts here if they could give us the technical context or detail for this, but one has to do with the public access to these improvements, because there are service plans that say if you are doing these, let's say, pool amenities, rec facilities, whatever they are, they have to be open to the public. And HOA by its tech, I'd like some input on what the technical perspective is on when you take that public asset and put it into a private corporation, and do they have an obligation to hold it open to the public? That I don't know. That's why I'm asking the technical question, and appreciate the speakers here who could address it. The other is the Internal Revenue Service implications if the debt's not paid off, you know, and what that looks like, because you've used tax exempt proceeds of bonds to pay for improvements that are to be public from the Internal Revenue Services perspective. So again, I'd like to know what the technical input is here on those thoughts and consequences.
Sure, I can address the second part there, which is what I was getting to with the, it has to do with the timing at which we're talking about a conversion, because if there is still debt outstanding, If those amenities that were paid for by tax exempt debt issuance cannot transfer to private ownership, or the tax exempt status of those bonds will be lost. So that's why I was trying to point out that if it's at the end and the debt has been repaid, that is one scenario versus probably an unlikely scenario of converting to an HOA if there is still debt outstanding at the time that they would like to make that conversion.
All right. Mary Ann, did that answer the question?
And then
that
still
answers
have the private improvements. What happens when, for example, so if there's a pool or a clubhouse, we are required as metropolitan districts to have that pool, clubhouse, fitness center open to any member of the public that would like to join. Yes, they can be subject to a fee that is similar to the taxes that are being paid by the residents themselves, or fees, but it would have to be open to the public. I think a big concern would come to bear when people in the general public have been used to be using the XYZ Metropolitan District pool. That community then decides, no, we are now going to become an HOA. This is going to become a private improvement. No, people, you can no longer use this facility. So that's more of a public policy argument and opinion there, probably on the impacts of that. But it is a fact that taking it from a public improvement to a private improvement would limit the access to numbers of people.
Yes, I guess the technical question of Tricia would be, can a private corporation hold a public improvement? Because if the service plan of the district required those improvements to be public, or agreements between the city or county and the district when they finance those were approved to finance those improvements that they be public, can an HOA hold something that's public? It's not a trick question. I really don't know the answer.
Yeah, and and I mean in the HOA world, I mean, those improvements are typically owned by the association, and typically they're just open to the association's owners and residents. But that's not to say that, and again, it kind of goes back to what's in the covenants, that the covenants couldn't then say, even though the association owns and maintains this clubhouse or this pool, we can allow members of the public to use them for a fee that the association, imposes. I guess, and again, I don't want to get too far into opinion, but I think you could run the risk of, the owners are in control of that declaration and amendments to that declaration. So the owners could then at some point amend the declaration to say, you know what, we're going to strip out that provision that says we can keep this open to the public.
All right. So I see we have Jennifer's hand raised and Commissioner Odoricio. And so I will have them go. And then I want to circle back to our legislators and make sure that we are discussing and revealing the right facts and information that's going to be helpful for the report as it relates to this topic. Because I know we are a little off script with our agenda, but that's all right. I just want to make sure that we're fulfilling our obligations here. So Jennifer, I'm going to have you go first.
Okay, thanks. And Representative Parenti, I feel like I heard something maybe a little bit different from what the last questions were going toward as far as your clarification of the intent. What I heard, and correct me if I'm wrong, is that you're not saying let's get rid of all districts and make them all HOAs. You're saying let's take the HOA powers out of a district and have them handled exclusively by HOAs, and then districts still handle public improvements as they have. And if they own a park, then they still own that park. Maybe there's a point where the community says we want to get rid of the district on their own and convert it to HOA. That's something that they can still do. They could do that now. And after the bonds are paid and all of the logistics that Elizabeth was addressing. But my understanding of what your clarification was is you're really right now wanting to peel out the HOA covenant enforcement design review and separate that from districts and have them handle the public infrastructure. Did I understand that correctly, or did I mess that up when I was listening?
I would say it was like 80 or 90% correct. So for sure, the intent of that piece was not to force all metro districts to become HOAs. That was not the intent of that piece of the legislation. It was more to ask this question of what is the process by which a metro district, for instance, after all of the debt has been paid, would or could be converted into an HOA? Is there sufficient statutory guidelines in place for how that could be affected? Or to what you already mentioned and what Mr. Matisse brought up before, what would be the process if, for instance, within a metro district to separate, right, those metro district really specific powers from the HOA community association powers? I think either of those two are really useful conversations to have. And I think these issues about, well, what happens to the HOA pool, right? If that happens, right? Like, this is really interesting. This is exactly the kind of conversation that we wanted to have to make sure that like all of that information came to light. But for sure, the intent of the legislation is not to say, let's look at turning all metro districts into HOAs. That's obviously like a totally different, yeah.
Okay, thank you.
Not a useful conversation to have.
I appreciate it. I think that'll help kind of guide our conversation a little bit. One of the other questions that I have, and perhaps this isn't a now, but a logistical item that would have to be overcome, I think, with if you're peeling out HOA, obviously prospectively, you have situations now where a district has that. So if you said all districts have to remove that power, I think you have a logistic issue as far as what if the members of that particular area didn't vote to create an HOA, and you have covenants in place. So you have the devil in the details there that I'm sure we don't have time to solve that world's problem right now. But I think that is something that we would have to overcome. I think prospectively, it's a much different discussion versus those that actually have covenants in place now for the district to enforce. So just tossing that out there for something that would need to be addressed. And I think that there are a lot of sticky logistics there that we'd have to talk through, but it's just wanted to toss that out there, and I'll stop talking.
Thank you, Jennifer. All right, Commissioner Odoricio, you've been very patient. Thank you.
All right, you guys are doing great. In fact, I think that the last interaction was really helpful to kind of clarify. We may need to address the issue of potential like bifurcation or diverting of these two entities of under the what is improvements versus covenants. And I mean covenants more or less along the lines of kind of performance of how you behave in the neighborhood. But I think it's important that we distinguish between the two. As far as me putting on my local government hat, if you were to come to the end of or the transition from special district to an HOA, I think it's important to remember that the creation of the special district did require some sort of service plan and oversight by the local government. And the reason that exists is so we don't say walk away and say it's now the local government's job to go handle this thing that the special district was supposed to do. It's also more difficult to enforce as a local government if somebody were to walk away an HOA improvement, which was never intended to be a public asset or liability. And so I would just say that as we go through, what I'm summarizing is separate the improvements and the capital piece from the kind of performance and behavioral issues, whether it's paint or whatever. And then the other piece is just let's think through the unintended consequences of some sort of transition as it would relate to local government, because folks in other portions of the community may not be keen on if there's a greater risk that they may have to pick up where somebody dropped the ball. Or just simply saying, hey, this park that we promised was going to be public, now it's going to be an HOA, or vice versa. And now the local government has to step in and clean up that mess. We've had a few of these situations starting to come up. So I just want to make sure that we keep in mind, also, in addition to local government impacts, we need to make sure the impact to debt and bondholders is sufficiently addressed.
Great. Thank you, Commissioner. Appreciate that. All right, Natasha, we'll go to you, and then we're going to do just a quick reset to make sure we're covering everything that needs to be covered. So go ahead, Natasha.
Yeah, it seems like a lot of discussion. Most of the districts I'm familiar with, it really is a matter of repaying the infrastructure bonds. But yes, there are districts that may have a park. To me, the logical one is that if there were to be a transition, the authorizing county or town under which the district exists, because again, Title 32 districts only exist to the extent that they are authorized and supervised either by a town or by a county, So maybe they'll service plan requirements reflect that any park or rec or common elements are to be to the public revert back to that organizational entity. And then two just comments, and hopefully not way off point. And I know we talked about this in the prior meeting, the eligible electors. I mean, a lot of this sounds good on paper, like all the organizational, the petition for organization, debt, election. That typically all happens before there's any homeowners in the district. When we talk about eligible electors, it's highlighted in the community where I live, in a second community. It's only a fraction of the people who can actually vote, because by the time we take out of state second homeowners, which are common here in the mountains, you take out all of those that have been put in trust for estate planning. And I know we have another session to address this, and those held as a business entity, we forget that that pool of voters is very restricted. And I guess the threshold issue that I had coming into this meeting today that I wanted to throw out to everyone, I find it deeply troubling that if I'm in the town of Granby downtown and I don't shovel my sidewalk, or I paint my house the wrong color, or I don't put my trash out on the right day, I'm not facing having my home foreclosed on. Why do we want to treat residents so disparately who's in a district, special district, versus a regular town resident across the street? So that's one that I've been chewing on for this whole meeting. I'd be interested in some response, but kind of on the topic that we have, if there's common elements that were intended to be public and financed with Metro District dollars, to me, the obvious solution is the organizational county or town. That needs to be part of a legislative requirement that if there are common elements, that they then get turned over to that organizational county or town. And sorry for my diatribe on the other two, but again, the disparity of how we would treat my failing to shovel my sidewalks versus a person just on the other side of the town line who's not in the Metro District, that troubles me deeply in today's discussion.
Thank you, Natasha. And we certainly can add that to the report so that it's filed. Those comments are noted with the foreclosure section. So appreciate you bringing that up. Christopher, I see your hand is up, and then we're going to do a little wrap up of the comments, but please go ahead.
I'm going to go real quick. What I've heard said is that much of what Natasha said, that the primary concern about having the district involved in the enforcement of covenants and performing HOA duties is the foreclosure issue. And if that's it, then let's figure out how to fix that. I can tell you that there's a ton of reasons, not the least of which were set forth by Elizabeth and Tricia, in terms of the transparency benefits that are associated with having the district perform all of these particular functions. I in fact have a community right now that has both an HOA and a district at the direction of the local government because they believe that that was a necessary evil. And the homeowners that are within it actually want to dissolve the HOA so that the Metro District can handle everything. They believe that the appointment of directors, the election of directors, the enforcement of provisions, the openness of the facilities, to the extent that Commissioner Ordorcio talks about the what ifs when an entity, particularly an HOA, can't maintain something and it gets dropped back in the lap of the approving local government for the district occurs, it's a huge problem. So I think that as much as there may be a concern about foreclosure, let's deal with that as it relates to these issues. And if we're going to provide for an opt-out, then let's provide for the opt-out going the other direction too, an opt-out to dissolve the HOA and in favor of having the district carry the responsibilities forward.
Great. Thank you, Chris. Appreciate that. All right. So I want to just pause for a moment because our conversation has flowed a little differently on this topic than it did the previous topic. Typically, we had set this up to have a conversation around what's working well, what's not working well, how do we have some improvement? But I think the nature of this issue was just a little bit different than the other topics. So we So we discussed it in a slightly different way. And so how we get there doesn't really matter as long as we've got the right information being brought to light for the purposes of this report. So I want to go back to our legislators, and particularly Representative Parenti, which I hate to put you on the spot, but I want to make sure that we are capturing the information that you had hoped we would capture in this conversation to be able to put this in a report so it's informative and helpful for the legislative audience that this will ultimately go to. And if it's not, then we can continue to have the conversation and maybe peel back a couple more layers on some specific topics. But you know, we want to make sure that we are having the conversation that we need to be having, even if we didn't answer all the questions quite in the order that we had planned. So let us know, how are you feeling right now in terms of the level of information that we've gathered?
I think in general, I mean, it's been a very good conversation and I really appreciate all the inputs. I think that a lot of this overlaps with the conversation of governance. And so and some of these conversations are going to come back when we dive into this a deeper dive on governance. For instance, how do the residents of a Metro District community dissolve their Metro District after the debt is paid off if they don't have governance control of the board, right? Like, if we can have all of those procedures in place, how do they access those procedures to move from a Metro District concept to an HOA concept? And I love the last speaker's idea of, well, what if they really want to go back? After they've separated the two, what if they realize that wasn't what they wanted to do and they want to go back? Great, like, let's have that conversation, right? Yeah, I think we're probably going to come back to some of the deeper conversations when we talk about governance. But yeah, this is what we hoped that people would talk about is, you know, what are these relationships and what does it mean to be a Metro District, and how do we give the residents the most voice into that sort of conversation as appropriate, understanding that, you know, there's debt, you know, management issues and so forth that also play.
All right. Wonderful. That was my sense, but I wanted to check with you to make sure that we were checking the box and getting the information that we needed. Question, I know that there have been a couple questions that have come up, and so in the chat, and I wanted to just make sure that everyone's questions have been satisfied as far as the discussion goes. I know Commissioner Odoriso, you had a couple of questions. Do you feel that those questions have been answered? Or are these questions that maybe need to be brought up in a future conversation?
I get the first question I have is, there's been a lot of discussion about enforcement of the HOA versus the special district. And so with the Metro District, you're kind of doing code enforcement. So my question would be is, how different is the process for a Metro District to enforce code violations, et cetera, versus a city and a county? Because I think it's important to know the difference. So while we were looking at HOA versus Metro District, I think it's also fair to know how do the cities and counties do code enforcement and show the difference, because I'm not sure we're allowed. I just want to see that process again lined up. The enforcement, the notification, because we're going through this in the county based on some feedback and some changes in the law that allow us also to do civil penalties as opposed to criminal. Then they also allow, and I'm not proposing that we start getting into allowing criminal on Metro Districts, but I'm just trying to figure out that, like, how is it differ? And is there a different level of draconianness that people are really concerned about? Because there's a lot of folks that I think there's a lot of evil out there with the local governments and Metro Districts. And I'd like to at least, I think more information is always better than not enough. And then Brian did help clarify that what I thought I heard is that at the end of the day, both Metro Districts and HOAs can foreclose, just with those little nuances. And I think we just continue to highlight those nuances and add what is the backstop that cities and counties use when somebody has truly not followed the rules. I'm not aware of us taking homes, but we can place liens on for costs of cleanup and other things.
So just I guess a question to our experts. I don't know, Tricia, Elizabeth, if you can lend any insight on this. I know it's a little bit outside of the box, but
Yeah, and I mean, I can speak to a little bit to kind of the process for enforcement for districts versus associations. Associations under Kiowa, I mean, we really do. I mean, the last couple of years, the legislature has revised Kiowa, so there's specific timelines that associations have to follow. There's limits on the amount of fines that associations can impose, and a district, you know, not being subject to Kiowa is not subject to those same guidelines and restrictions that are in Kiowa. Most districts that do enforce covenants, I think, have a covenant enforcement policy in place that sets out the process that they follow and the fines that are imposed. So kind of similar to the conversation that was had during the foreclosure discussion, districts aren't just, going forward with no notice. They do follow a process before they impose fines on an owner for a covenant violation. And I can't speak to what cities and counties do, so.
Does anyone have anything else to add on that question? Okay. Well, we are almost at time. We have a couple of housekeeping matters to still discuss, but appreciate everyone being flexible on our discussion today. This was just the nature of this topic just proved to be a little different, but it sounds like there's consensus that the issues that were needed came to light, and we were able to capture that information. So I do want to just thank Elizabeth and Tricia for their expertise in guiding us through this conversation. And I know David has already hopped off, but I want to thank him for leading us through the foreclosure technical information at the beginning as well. We really appreciate everyone's time when they can share their expertise with us. So I wanted to go through just a quick couple housekeeping items. Our next meeting is scheduled for January 22nd. That topic will be governance policies, including voting and elections. Our meeting on February 5th is going to cover tax levying authority and practices. And then our February 19th is our final meeting. That is when we are planning on discussing the results of the HOA report that Representative Prenti had discussed earlier, as they're working through some of their own recommendations and other emerging topics. But before we conclude, because we are 3 meetings in of our 6-meeting series, I did just want to check in, the whole facilitation team just wanted to check in with all of you as a task force and make sure that this process is valuable and useful for the purposes of this report. So just to refresh everyone's memory, the scope of our work together is defined by the task force as examining issues confronting communities that are governed by a board of a metropolitan district. These issues include, but are not limited to, the 5 stated topics, which are tax levying authority and practices, foreclosure practices, communications with homeowners regarding metropolitan district processes, and homeowners' rights and responsibilities, governance policies, including voting and elections. So that's straight from the language. So our purpose here together is to facilitate this report that just illuminates all of these topics that were mandated within legislation. So at the first meeting, our very first meeting in December, we presented a format for each session that would include that expert education followed by facilitated discussion. And since we are at the halfway point of these sessions, I just wanted to invite your input on how you feel these sessions are going. If you feel that this format will help the task force meet these objectives, and if you have any suggestions for refinement that would possibly benefit this process. So I just want to open that up to you all, since we do have a couple of minutes to just get your feedback on this, because, again, our job here is to make sure that we are providing you with the right information and the right format to facilitate that conversation. And we are at the halfway point, so this is a good time to check in. So would love to hear your thoughts on that. Natasha, go ahead.
I'll jump in with one observation. And I really appreciate Representative Parenti saying that, our goal here is to give the residents the most voice possible. And there's a lot of education, with Title 32 needed. This whole foreclosure, when I first brought to my attention, I had no idea how extensive these powers were. I think when we have expert education, if the goal is to help homeowners, it's maybe have that more balanced. It seems like we hear from a lot of industry experts. So a little more balance maybe in the presentation would be helpful.
Thanks, Natasha. I appreciate that. Representative Parenti.
Thank you, Sarah. I understand that the HOA task force recently had a meeting dedicated to public testimony. And I would really appreciate the opportunity for members of the public who have stories they want to share with this task force to be given the opportunity to do that in the standard, 2 to 3 minute testimony process. But I think there's a lot of people out there who really want to have their voices heard on this topic.
Thank you, Representative. Let's see, Commissioner Odoricio, please go ahead.
As we get into discussions of what I think is somewhat a HOA versus Metro District discussion, I think today what really dawned on me is that I want to make sure that they don't triangulate and just hand it off to the cities and counties to handle, be the catch-all of problems that occur. And I think that's only fair. I think it's also important that there's not a lot of pushback. I know we're getting a lot of the criticisms put on the table, which I think is fine for us to do right now, of criticisms of Metro Districts. And there's plenty for Metro Districts and HOAs, but I also want to recall that there are also certain things that are enforceable to try to keep the standard of a community at a certain level. And quality of life means a lot. And I get a lot of complaints as somebody who has both or all three, no Metro District or HOA, HOAs, and governed special districts or Metro Districts. And it's important that when people enter into a neighborhood with certain expectations and standards, that they know what they're getting into. And I'm talking separately from the finance that we've talked about before, but there are standards of behavior that we need to make sure that are still ultimately enforceable. And to simply say, I'm going to paint my house pink and have no consequences for that. Well, the neighborhood that you entered into is not supposed to have pink houses. And I think it's okay to say that there needs to be some sort of enforcement at some point for bad behavior. Cars parked on blocks in the middle of the lawn, the weeds and things like that. I understand sometimes it could go too far and you get the super HOA, we used to call them the HOA Nazis, like coming down hard on only certain people or others. But what I'm saying is that there's still a certain level of quality of life that is fair, especially when that expectation was set up front. And then, so that's the second thing. Number one was the impact to the cities and counties to not be the catch-all. And the second one is there's quality of life. And I also think it's fair, finally, that we just continue to recognize that as they exist now, Metro Districts are stretching out some of the cost of some development that would otherwise be placed on the upfront price tag of some of these homes. And so we have to recognize that what we do impacts ultimate affordability. And so there's communities I have that would be $750,000 homes, but can make them $550 because they stretch it out. The challenge that I have as an elected official is people not knowing what that stretched out is. And I think it's important that they know what they're getting, and they know that the high watermark that they may start out with $1,500 of costs. And I know I'm getting back to cost, but $1,500 cost goes up to $3,000 in 5 years. That's important for them to understand. But I want to keep the element of affordability at the forefront of what we do, because no offense to my legislative friends, but we have this conversation a lot, unintended consequences. And we got to make sure that we think about affordability as well.
All right, thank you, Commissioner. Chris, I see your hand raised. You can close us out.
Oh, boy. I think that your recitation of the tasks and scope of this committee was eye-opening for me. And I have some concern about just how far astray we may go. I know for today's conversation, we were talking about foreclosure issues, and I don't want to diminish them. And I think, frankly, that there's a lot of different ways to come back and address that particular issue. But I don't want, as a part of that, to stray into the kinds of things and concerns that the commissioner just mentioned, as well as broader concerns with regard to the function of Metro Districts and, say, those versus HOAs. So I think we have to really look to define our scope and stay within the scope. And if we need to broaden that in some particular area, or we need to meet for a beer and discuss these things in a broader context, I'm all for that.
Thank you, Chris. It is helpful for us to just keep in mind the scope of this. And we are at time. So Brian, if you can promise me you can keep it short, you may go ahead and go.
Yeah, thank you. Very short. I want to emphasize that this is called the Homeowners Rights Task Force. And and Dora has solicited a large number of comments from homeowners, written comments. After 3 meetings, I want to follow up what Representative Prenti said. We haven't had any homeowners issues addressed here so far. In other words, we haven't heard from any homeowners. We haven't looked at the documents yet that were submitted of some of the concerns, and I think that needs to be addressed. I originally solicited or mentioned several. I'm not sure how these experts are chosen or who picks them, but I originally mentioned several people that could present some of these issues. I mentioned Jeff Withers, for example. I mentioned a couple of other individuals, and I don't know if they've been contacted or not, but it just seems like we're only hearing one side of it on the experts.
Thanks, Brian. And Representative Prenti definitely got your note regarding hearing from some homeowners. So we'll definitely take a look at that. So wonderful. Well, Chris, did you have one final comment? Because we do need to wrap up.
No, I forgot to take my hand.
Okay. All right. That's the best kind of comment. Nope. So, wonderful. Marcia, is there any final closing comments before we wrap up?
I don't have any. I think we can adjourn the meeting if everybody else is agreeable to it.
Thank you. All right, wonderful. Thank you, everyone, for a great conversation today. Really appreciate all your time and expertise and look forward to seeing you again in 2 weeks.